folks, and welcome back to Conveyancing. This is video 1 in the video series dealing with formation of contract. And we'll jump into our Prezi and you'll see there's a number of different topics that we need to get across for this video series. Firstly, we will be dealing with formation of contract and the various different statutory requirements in the Property Law Act. Then we'll have a look at a ragtag bunch of other topics, and that will be in the second video series. The cooling off period, obviously a very important point that you need to be across for your clients. Installment contracts, prohibited transactions, and finally the big one, the deposit. A lot of squabbles get fought over the deposit, as you can well imagine. So firstly, let's jump into formation of contract. So the way we're going to work this video series is we are going to look at the various different components of Section 59 of the Property Law Act, and I've got them highlighted in yellow there for you. Essentially what we are looking at is the modern day equivalent of the old statute of frauds requirement for writing, so that people couldn't just prove a contract by way of oral agreement. And so we will carve up Section 59 into its various different components, as I said, and then we will have a look at a few other issues: variation, discharge and waiver. Are they the same thing? Are they different? That's a teaser for you. And also estoppel. Okay, so the first component that we need to look at is that there has to be a contract for the sale or other disposition of land. There's a lot packed into that, contract for the sale or other disposition. And firstly, what is a contract for sale? What is a contract for disposition? Well, believe it or not, there has been a squabble about that, and it has been held in Radaman and Vexapoo that the contract has to either result in or effect the sale or disposition. It's the vehicle, it's the mechanism by which the sale or the disposition occurs. So effectively what that case tells us is that one of the parties has to come under some kind of contractual obligation to sell or dispose of their interest in the relevant land. Now, what is a sale? If you have a look at Schedule 6 of the PLA, it very helpfully says that the sale means only a sale property, so properly so called. It seems a little bit tautologist, doesn't it? A sale means a sale properly so called. Case law fleshes that out a little bit for us. Robshaw Brothers and Mayer tells us that a sale must be essentially an exchange of property for money, okay, not money's worth. So, for example, a conditional discharge of debt in exchange for property is not a sale. Okay, so sale tends to be defined and interpreted quite narrowly. However, we know that it's not just contracts for sale, but we can also have a contract for disposition, other disposition of land. And disposition sweeps in a lot of extra things that a pure sale will not sweep in. Okay, so the legislation, Section 59, is considerably broadened by dropping in this phrase or other disposition. What is exactly a disposition? If you have a little look at Schedule 6, it's inclusive drafting here, including a conveyance, vesting instrument, declaration of trust, disclaimer, release, and every other assurance of property by an instrument. Okay, very, very broad. And as you can see there, power, sale, and casino. It includes such things as an agreement by two parties for one of them to transfer their interest to a third party. So it sweeps in a lot of extra transactions, the phrase, well, the word disposition. However, it excludes transactions that would occur under a will. So except a will, release, devise, bequest, or appointment of property contained in a will. So that is contract for the sale or other disposition. land or any interest in land. So you need to have a contract for sale or other disposition of land or any interest in land. Here we need to skip over to the Acts Interpretation Act, and you will see section 36 then points you to the schedule. And in the AIA, we have land being defined as including. So again, inclusive drafting, broadly defined drafting, messuages. So what is a messuage? It's not a, that's not a typo. That is how it's spelled. So that is the house plus as much of the land around the house as is necessary for its enjoyment. Okay, so that's a messuage. Tenements, these are any property the subject of tenure. So within your freehold connected to the land, usually tenements are permanent interests in land. Hereditaments, these obviously are capable of being inherited. So things like a life interest obviously will not be a hereditament because you can't inherit it. You can't pass it down. They may be corporeal or incorporeal. So corporeal hereditaments will be things like your land and your buildings. Incorporeal will be your rights, you know, like easements and profits of prendre and things like that. Corporeal, as I said, or incorporeal, of any tenure or description, and whatever may be the interest in the land, of any tenure or description, and whatever may be the interest in the land. So very, very broadly defined term there. That is land in the Acts Interpretation Act. Interest in land, according to the AIA in that same spot, dictionary, it's a legal or equitable estate in the land or other property, or a right, power or privilege over or in relation to the land. And Bradshaw and Henderson in that case, basically they read that definition in the AIA down for the purposes of Section 59 of the Property Law Act. And they said where you're looking at the requirements for proof before you can go ahead and take an action on a contract for the purposes of the PLA, really an interest in land is going to be confined to the definition in the AIA that equates to that first limb that I've got there, paragraph A, legal or equitable estate in the land or other property. It doesn't extend out to things like a right, power or privilege in relation to the land. So a little bit of narrowing there, but generally speaking, land will be fairly broadly interpreted. What does an interest in land include? Obviously it includes your freehold, leasehold, mineral interest, that kind of thing, lots in community title schemes. It does not include things like a license to use the land or goodwill of a business, things like that. Note the little interesting and historical kind of quirk that the authors of the text decide to mention there. There's a series of cases that have held that if you actually sell trees that are going to be growing on a particular portion of land, and the trees will be felled at a certain girth once they've gotten so many inches wide, or centimetres or millimetres, I guess nowadays, wide, then that will be a contract for the sale of an estate in land, okay, because the trees need the land to survive. So that is an interest in land. So you can't take action on a contract for the sale of land or an interest in land, or disposition. And here we come to the big unless, okay, unless the contract or a memorandum or note of the contract is in writing and signed. Okay, so all of that stuff presupposes the fact that you've actually got a validly constituted and legally binding contract in place. Okay, so revision from contract A, you know, you need to have all the usual formalities, price, parties, property. In Queensland, a little bit different to New South Wales for all you New South Welsh people, we don't have the whole contract being formed upon exchange here in Queensland. We have the usual way that it goes is you'll get a sale contract that's been drafted up by the real estate agent. They will give it to the buyer to put their offer down in writing, and then they'll take that, they'll sign it, they'll take that away to the seller. The seller will either accept it or not. If they do accept it, they'll also sign. Then the real estate agent will generally deliver that back to the buyer. If they're prudent, they'll probably ring the buyer the minute that the seller has actually agreed, and then once you've communicated, then the contract has formed. The text goes into a little bit more detail in terms of you know, the instantaneous rule and all that kind of thing for contract formation, and where contracts get formed by email is where that generally tends to cut in to this area. Obviously, the buyer can withdraw any time until communication of acceptance. So as I said, if the real estate agent is prudent, they're going to ring as soon as the seller has actually signed on the dotted line. They're going to eliminate any point of time in which then the buyer can back out of the deal. The final issue then that the text goes into is just having a look at where you are not using a standard form contract. Is this the kind of contract that indicates the parties intended to be immediately bound? And here we have all of that good Masters and Cameron stuff that we learned in contract law. Was the contract made, was the agreement made subject to contract, or did the parties actually intend to be bound? And there's those 3 or maybe 4 categories of agreement there that you know, you can filter through and look to see whether the parties actually intended to be bound upon signing. I'm not going to go into that here. That's more revision stuff for you to have a look at. Now, if you don't actually have a contract in writing, all is not lost, obviously, because you might have made a memorandum or note of the contract. Now, if that's what you've got and it's in writing and as we'll see, signed, then that will suffice for the purposes of the Property Law Act. It has to contain all this memorandum or note, has to contain all of those essential terms that were in the parties' oral agreement. Okay, so it has to put down parties, property, price, all of that good stuff. If time's of the essence, then obviously you're going to have the date for settlement in there. Anything else that's been made essential by the parties, and you need to have an acknowledgement of agreement to the terms. Now that can be express, it's more often implied. You can go ahead and use a number of different documents to prove this point if your client unfortunately ends up in court and needs to prove for the section for the purposes of section 59 that the agreement satisfied the PLA. So for example, you might have the offer being contained in one document and then a subsequent document constituting the acceptance in writing. All of that kind of stuff is revision pretty much from Contract A, so I'm not going to labour the point. Obviously you can have emails as a memorandum that will satisfy section 59. They do discuss the difficulties that can be, I guess, in a rather academic sense, encountered in terms of looking at the Electronic Transactions Act and trying to figure out whether electronic writing is going to be sufficient writing for the purposes of the PLA. They say that the Electronic Transactions Act kind of is a bit clunky with the way it works in terms of interfacing with the PLA. But at the end of the day, electronic writing will be writing within the Acts Interpretation Act, so you're pretty good there. Case law certainly bears that out. So that is your memorandum or note of the contract. The memorandum or note or the contract itself must be signed by the party to be charged or an authorised nominee. So what exactly does that mean? Well, if you're the buyer and you're the one that wants to take legal action on this contract, then the seller is the party to be charged. So it's important that the seller has signed this contract. If it's the seller that wants to enforce the contract, then the buyer will be the party to be charged. So technically you don't have to have one document with two signatures on it by both buyer and seller. It's enough if you are wanting to take action on the contract that the other party, the respondent to your action, has gone ahead and signed the document. Yes, the paper document that the authors say is normally signed by making a mark. Reminds me of the old, X marks the spot. But the mark has to do a few things. It has to identify the party. It has to indicate that they approve of the contents of the document. It has to indicate they agree the document is binding and of legal effect. And what essentially it does, it provides integrity for the document, that is, in terms of reliability so far as any court actions on the document are concerned. Generally speaking, where a party's name is just typed into the document or handwritten into the document, if the nature of the document indicates that it was contemplated that that document would be actually signed, then that's not going to work for the purposes of the PLA. So just because you have a contract there that's got, this is a contract between Joe Smith and Mary James up the top there, and then at the end you've got the signature block. Obviously that document will contemplate signature by the party, so just having their name in there isn't going to work for the purposes of the PLA. You can understand why it's obvious, isn't it? Now, if the contract is not signed by the party to be charged, it needs to be signed by some form of authorised nominee. And so you might have your agent or an auctioneer or a solicitor signing the contract instead of the party to be charged. This stuff should all feel very reassuringly and comfortably familiar. We traversed this kind of information in contract law, so just touching on it once again in terms of agents. We also looked at this agents and solicitors in weeks 1 and 2 of this unit, so it should be really clear as a bell by now. In terms of agents, you can give an agent oral authority to actually go ahead and sign the contract for you, but if it is clear from the face of the contract that that contract is supposed to be signed by the seller, then you're going to have express written authority for the agent to go ahead and do that. Fairly unusual. Auctioneers is probably the most common, and as you'll remember from contract, in terms of the seller's authority for the auctioneer to sign, that will be granted via the auctioneer's terms of engagement. In terms of the buyer authorising the auctioneer to sign, just by them, going through that whole auction process, registering to bid and then actually going ahead and bidding and then being the highest bidder, then having the hammer fall, all of that authorises the auctioneer to then go ahead and sign for the buyer if for some reason the buyer does not wish to do so afterwards. Note of caution, as the text points out, this has to be done contemporaneously, so it's no good if the buyer is recalcitrant. The auctioneer can't just delay and hope that they'll convince them to sign in a week or 2 weeks. It's all got to be done within a few hours of the auction actually happening, within a few hours of the hammer falling down. Solicitors, we already know about that. Generally speaking, solicitors will not be given authority by either buyer or seller to sign for them. It's something that you would only undertake in the rarest of circumstances, and only then with express written instructions. Obviously, the warning signs are all around that, aren't they? So that is signing by the authorised parties. The text does look specifically at the issue of signing electronically and the way that the various different electronic signatures can occur nowadays. So obviously you've got e-signatures. You might have an electronically typed name, scanned signature. I use that one. Clicking accept, sometimes you have the buttons. Sometimes you have a user ID or password. And then you've got that whole next level of security, the next gen stuff really that's happening now. So the digital signatures are much more secure with encrypting technology and different keys that have to be set up. The digital signature is a far more reliable form of signature, but you don't have to go to that level of security for it to suffice for the purposes of the PLA. In terms of e-signatures, you've got a whole mixed bag of authorities there. Most of them come down on the side of electronic signatures will be acceptable. England, there has been a little bit more mixed authority. Mostly, as I said here, it tends to fall down on the side of yes, an electronic signature will be okay. The text does talk about this authenticated signature fiction. And that can be a useful device for satisfying the PLA. What you have to have there is the party's name being typed on the note or memorandum of the contract, and then they acknowledge the written name as an authentic expression of the will of the contract so far as they are concerned. And then what happens is the court will deem their signature to have been applied. Useful little device, but generally speaking, now that electronic exchange of documentation and electronic signature is becoming such an accepted form of doing, transactions and business forming contracts, there's not a whole lot of problem with electronic signature nowadays. The authors do go into the requirements for the Electronic Transactions Act. And the main thing there, the main 3 bullet points there is that the ETA requires that the method is used to identify the person. It was as reliable as was appropriate and proven to have fulfilled the functions of the first bullet point. And the last bullet point there, the person to whom the signature is to be given consents to the requirement being met by using the method. As I said, there's not a whole lot of uncertainty around this now. It will just come down to the facts of a particular circumstance, whether or not those general requirements are met. So does the signature identify the person? Does it indicate their intention? Generally speaking, under the ETA, as I say there, you've got loads of case authority that easily establishes that the ETA will allow both digital and e-signatures. You don't have to go to the level of security of it having a digital signature. E-signatures will do. It has to be as reliable as was appropriate. Doesn't have to, again, be up to the level of security of an actual digital signature. It just needs to prove their identification and the intention that they have in relation to the document. Parties have consented to use of the method. Generally, if you're going to be negotiating by email, then you're going to be have taken to have consented to use of the method. It has to be proven, in fact, to have satisfied your point 1, and as I said, there has to be consent there. Really, the take-home message in all of this is that it is fairly easy to both form a contract electronically and sign a contract electronically with the various legislation, assisting you and devices, various different devices like the authenticated signature fiction, giving you loads of assistance. And there is a warning there. Take care if you are negotiating by email and you have put your name to an email be quite cautious, because it's more than likely that you may well have satisfied the signature requirements under the PLA. That is all we really need to say about signing. And I think probably the next video we will look at what happens now if your client has fallen short of the requirements of the PLA, and the various different ways that you can get around that. As you all know, we're lawyers and there's more than one way to skin a cat, isn't there? So I will see you in video 2. Bye for now, guys.